stop the fighting. One love, one unity, got to break the bondage. No more borders around me, no more mental slavery. Bob Marley said it best, stand together and feel alright. But if we fight,
let it be for justice.
and if we war,
Let it be for justice.
at all costs,
Let it be for justice.
do what is right.
Let it be for justice.
Let it be for justice. Let it be for justice. No matter what it costs, let it be for justice. Let it be for justice. Inequity, disparities, and violence, oppression, racism. No, I won't be silent. No more barriers for we. We will thrive, prosperity. Marcus Garvey said it best. None but ourselves can free your minds. But if we fight,
Let it be for justice.
and if we war,
Let it be for justice.
at all costs,
Let it be for justice.
do what is right.
Let it be for justice.
Let it be for justice. Let it be for justice. No matter what it costs, let it be for justice. Let
justice. Let it be for justice.
We the people are from royalty. Royalty. I wish so many of us can see. Keep the culture, be united, stop the violence. Put the power in ourselves, create the franchise. In the news last week, another bomb overseas. I'm so sick of these murders in the streets. Ooh, boy, ooh, boy, boy, boy. But if we fight,
Let it be for justice. Let it be for justice. Let it be for justice.
Greetings and salutations.
For justice.
let it
Welcome to the community and finance edition of the Night Shift with DJ Kevin Steele.
one unity, got to break the bondage. No more
I want to say big ups to those who are near and those who are far.
but
Yeah, the not so near ones.
let's stand together and feel alright. But if we
On whatever platform you're locked in on.
Let it be for justice.
if we want
Those on TuneIn Radio, big ups to you on the Night Shift with DJ Kevin Steele.
at all costs.
I'm glad you could tune in.
Let it be for justice.
Those hailing from across the pond, One Ham on the radio. Top of the morning to you guys over there in the UK.
Let it be for justice. Let
King Genius, Queen Genius, much love to you.
this, no matter what it costs. Let it be for justice. Let it be.
I want to say big ups to those who are locked in on the Foundation Radio Network, ClintonLindsay.com.
Season violence.
Big up Mr. Lindsay.
No, I won't be silent. No more. No
Those hailing out of New Jersey
we will
on NIE Radio.
see. Marcus Garvey said it best, none but our
My brother, the motivator.
but if we fight,
Let it be for justice.
and if we want,
Also out in New Jersey, those locked in on Mix102.com.
Let it be for justice.
Out of Jamaica, Earth 96 FM.
Be for justice.
let it be for justice.
Blessing Symbol.
Let it be for justice, no matter what it costs. Let it be for justice. Let it be for justice. Let it
Those locked in out of New York,
let it be for justice. No
exhibiting the power of music
for justice.
on Island Worldwide. Big ups to you.
We the people are from royalty.
Big ups to this lady right here. Yeah, that you hear in the background. It's China Nicole.
And see. Keep the culture, be united, stop the violence.
Track call it Be for Justice.
Create the franchise. In the news last week, another bomb
Gary and the Jump Out production crew.
murders in the street.
Much love to you guys.
Ooh, boy, but if we
Those who are locked in on YouTube Live.
Let it be for
Those bubbling in the stew pot on Zeno FM. And on Clubhouse.
justice.
Big ups to you.
Let it be for justice.
And of course, those right here at the home of the Night Shift with DJ Kevin Steele, where you're encouraged to have acceptance through enlightenment
let it be,
on kevinsteele.com.
let it be for justice, no matter what.
So glad to have you. Couldn't do it without you.
Let
Believe me, I have my word. I wouldn't even try.
it be,
Inviting you all to call a friend, tell a friend, friends of your friends, friends of your enemies, enemies of your friends, and your enemies too. Call up somebody, anybody, everybody. Let them know.
Be for justice.
Community and Finance Night is tonight.
Let it be for justice.
And we're revisiting a topic that we haven't touched on in months. But just know
For justice.
the fight for justice continues.
justice. Let it be for justice.
Not because you don't hear us talking about it right here, does it mean that things are not still happening.
Let it be for justice.
I know for one, there's one guy
Let it
who doesn't keep still when it comes to this particular case.
be for justice.
I don't think he knows how. And so, without further ado, I present to you someone who is no stranger to the Night Shift to DJ Kevin Steele. No stranger to, well, a little bit of conflict. The one and only. The man who Since I started presenting on this topic, I've been using this picture. Fish, I think we need a new picture. Ladies and gentlemen, Mr. David Fisher. Oh my goodness.
You must have the clap soundtrack from Saturday Night Live. Let's hope the acting is better.
Well, let's hope so. You know, we've had quite a bit of practice with this.
Right. Hey, I just want to go ahead and dedicate this to one of our friends that's moved on, to Donnie Walker.
Yes.
Kind of miss that character.
Yeah. May his soul rest in peace. He started the new year and never saw the sunrise in 2024.
Yeah, but he did give us some beautiful sunsets, and my thoughts always reflect on him like a morning sunrise. I mean, he was definitely a character that had to be respected, and he led a principled life.
Yes, that is very true. Big ups Donnie Walker, WGLRO. He was the man behind it all, and he'll be forever loved and missed, but not forgotten.
Yes, no, he'll not be forgotten.
You know, if it wasn't for him, I wouldn't have known you. So, you know, there's a lot to. Well, I don't know.
And that worked.
Thanks?
That worked both ways.
Is that thanks?
Kind of like that Australian boomerang thing. It's it starts, it ends up where it started, and it starts where it ends up. So
Right.
that circle of life, unless it hits you on the rebound. So anyway, got some interesting things going on in Rodney's case, and unfortunately, a lot of the same. We hadn't talked, but you are aware that Rodney's attorneys filed a motion this last December in his case in federal court.
Yeah, I caught some wind of something. I didn't read the motion. I did catch wind of something though.
Yeah, you can find it on his Facebook page, but it's typical innocence project BS. They're going back and they're saying, oh, they withheld information. Oh, this is a federal violation. The state argued that Reed didn't know Stacy, and so Rodney's DNA and Stacy's were evidence of the crime, when all these people the state knew and withheld had known Stacy and Rodney were in a relationship. Yeah, problem is that's real late, to be bringing up.
Yeah.
And in the eyes of the state and the feds, it doesn't say he's innocent. I mean, people who know each other kill each other. I mean, that happens.
That's true.
That's not going to get you anywhere. What has to be brought out is the evidence, and the officials who brought the charges lacked authority and hid actual physical evidence. And see, that's different. And that's what the Innocence Project won't do, because they know that it will acquit, it'll get the conviction thrown out. And that's not the intention of the Innocence Project. If that was the intention of the Innocence Project, they would be aware and looking and listening to those of us who have done the research. Now, just to bring the listeners up to speed, there was a ruling by a special court of review set up by the Texas Supreme Court in January 2022. And that ruling was that any appointed or elected official in Texas who has any judicial powers granted by statute or the Constitution is a judge, whether they've ever taken the bench or not, and are under the authority of the Commission on Judicial Conduct. So what does that mean? It means what I've been trying to tell everybody for the last, almost 20 years. Medical examiners in Texas are judges. They are not physicians charged with doing autopsies. They're judges charged with conducting judicial death investigations, and the autopsy is merely a discretionary tool of the inquest. And in Texas, a judge has to take and file their oaths before they are a judge. You cannot be a judge, you cannot have any authority or any powers unless you have executed and recorded your oaths. And if you take any official acts without having executed your oaths, all those acts are void. Not voidable, they're absolutely void. So let's go to Bayardo, who did the autopsy. As a Travis County medical examiner, he's a judge if he took the oaths and if he was appointed. Bayardo was neither appointed nor did he take the oaths.
How did he get the position?
He, through a complete screw-up by the Travis County Commissioner's Court. And it had a lot to do with alcohol. And one of the commissioners on that court who ran the operation, being an alcoholic. And everybody knows who that is. They just don't know who it is. She's best known for the little quip about George W. Bush when he was running, for president. Says, poor George, he was born with a silver spoon in his mouth. That was our former governor, Ann Richards. In 1978, she was a commissioner on the Commissioner's Court that was running the appointment of the medical examiner.
Okay.
And they didn't appoint him. They entered into a contract with him in 1978, but it was a one-year contract that had to be renewed in 1979, and they simply forgot and never did.
So his contract. I have that contract from some time ago because this was one of the arguments. Now, people, those of you who have been listening to this broadcast forever, and those who have come on along the way, I started presenting on the Reed case in 2019. That was when I met David, and that was the last day of execution for him. And for Reed, sorry. Well, some people have been trying to kill off Fisher, but well,
not with love, I can assure you of that.
However, ever since we did our first presentation and moving forward, this has been one of the arguments that you've presented, and you've presented documented proof of various records requests to refute your argument and have found none. But yet you have found documents that support your argument. Now, for those who are listening in and want to participate by asking questions or giving comments, feel free to do so. The number is 773-789-STEW. 773-789-7839. And occasionally you'll see it scrolling across the bottom of your screen. You can use this number to call in. You can call, text, WhatsApp, Telegram. They all work. I do ask that you either call or message in the stew pot, or even on YouTube if you're watching on YouTube. Those of you that are locked in on Clubhouse, go ahead and use a Clubhouse chat if you want to. But I encourage everyone to either use the YouTube or the stew pot on kevinstew.com, which is what others call a chat room, but because we're fancy, we call it a stew pot. It's the interactive portal where we keep things bubbling. So use up those avenues. The phone number, again, 773-789-7839 is scrolling across the bottom of your screen right now. Call us. Share your ideas, your views. Let us hear what it is that you have to say, because we deem that also important, right? Now, Vish, back, let me see if I can find that document. There was a document where you had a couple of documents you had sent me. No renewed contract for Bayardo is one of them. Let me see if I can pull up this information
Yeah,
here.
those would have been back in 78, 79, but the requests were made in, top of my head, those have been 2018, maybe.
Okay, here I found
19, yeah.
A document dated July 24, 1973.
Okay, not 73.
Oh, wait, what's it, 78?
78.
78. Okay. And it's the print. Let me go ahead and share this with people so that they can see it. Because they must be asking, Stu, what are you talking about? We're not seeing anything. This is a document that I'm looking at. Authorization for the county judge to execute a contract with Robert J. Bayardo, MD, as medical examiner. And that's item 12. Item 13 shows the approval order. Appointment of election judges. Item 15, awarding bids. And it goes on. And then you show the contract is there. Agreement made this 24th day of July, 1978, between Travis County having a principal place of business at the Travis County Courthouse, Austin, Texas, hereinafter referred to as the county, and Roberto J. Bayardo, MD, hereinafter referred to as the doctor.
And see, that right there is a felony in Texas. Contracting with a doctor. Texas has a strange law. Mm-hmm. It's called corporate practice of medicine. It is a felony for a non-doctor to contract for medical services with a doctor. Only doctors can contract with other doctors to perform medical services. You see, the medical examiner, as pointed out, is a judicial officer, is a judge in Texas. And you're appointing a judicial officer, as the conditions set by the Texas Code of Criminal Procedure is that judicial officer must be a licensed physician. Mm-hmm. So that he may perform an autopsy, which is a medical act in Texas. But in Texas, unless the Constitution exempts you or allows you to contract with a doctor, it is a felony to do so. So the Commissioner's Court of Travis County has never, not even to this day, been given the authority to contract with a physician to perform autopsies. In Texas, the statute is that the medical examiner conducts inquests with or without a jury on all of the enumerated deaths under the statute. And that lists everything but a natural death under a doctor's care. So, and see, this is something that the media has never disclosed in the whole history of the medical examiner statute. And the medical examiner statute came into existence in late 1955. But it's never been disclosed to the public that the duty of a medical examiner and a justice of the peace is to conduct a judicial inquest. And you see, when they do these inquests, if they order or perform an autopsy, they must write an inquest report and file it under seal with the district clerk, of the county, to be only opened by a district court judge. And it's not any judge. It's the judge who impanels the grand jury to investigate the death. The inquest report is the first official record of the grand jury. That is what our system is in Texas. That's the black and the white of it, and it's never done.
But you say it hasn't been put out there in the public, but this is public information, though.
This is part of the statute, and it involves every death in Texas, but a natural death under a doctor's care. Or an accidental death where no one is at fault.
Okay.
But all other deaths require inquests, judicial death investigations. And here's the other nasty little part about that. Only a judge can sign a Texas death certificate for a death above a natural death under a doctor's care. If a physician cannot sign the death certificate, the only other person that can sign the death certificate is a judge in Texas, either a justice of the peace or a medical examiner. And see, these are key issues. So in the case of the death of Stacy Stites, Bayardo declared the death a homicide. It was because of that declaration of a homicide that Bastrop County prosecuted Rodney.
Okay.
If Bayardo had no authority to touch that body, then all the evidence collected, all the DNA evidence, everything he collected could never be introduced in a criminal court of law in this state. Because he has no authority. And performing the autopsy constitutes tampering with a corpse. An abuse of a corpse.
So, just with that information alone, we could pretty much say this broadcast is over because we need not go any further.
Right. If Rodney's attorneys were, now you got to understand, Barry Scheck and all of Rodney's big hard-hitting attorneys, less one, who's is mostly a joke than he is anything else. All those other attorneys are in New York. It's kind of like a pecani sauce here in Texas. You don't want it made in New York. If you want a hot sauce, you want it made in Texas. Well, these guys don't understand Texas law, the nuances, none of it. And the only attorney such that you could say he is on Rodney's case that's in Texas and went to a Texas law school is Quincy McNeil. And I've dealt with Quincy McNeil since 2001, 2002. And if I could put him in jail, I'd do it. The guy, I would never, even my worst enemy, would I advise to hire Quincy McNeil. In my opinion, he's a fraud. In my dealings with him, he's a fraud. And I was the one that asked him to join the Reed's team in order to bring the truth to Rodney so Rodney could corral his attorneys and force them to do his bidding, which is what's supposed to happen, is that it's the defendant who makes the decisions based on the advice from the attorneys. Well, if the attorneys are lying to you, what chance does a defendant have? If the attorneys won't do what you say, what chance does a defendant have? But I'll tell you this, the courts hold the defendant responsible for what his attorneys do or don't do. See the catch-22?
Yes.
The attorneys won't. The attorneys are paid by the state, and in most cases, in Texas, the attorneys are appointed by the judges. But then the attorneys don't tell their clients the truth about anything, and don't help the clients understand and make their decisions. Yet the clients are the ones who are held solely liable for the mistakes or the lack of actions of their attorneys.
No,
and this is the stuff that really, POs me.
No, that's a real catch-22, because when you look at all the connected dots, the defendant tells the attorney what to do based on the information that the defendant gets from the attorney. That is appointed by the state that pays them. But when you're talking about a case like this, where it's the state versus the state represented, or the state versus an individual represented by the state. Yeah,
that's paid by the state.
So the state is going up against itself.
In essence, because you say, oh, well, but you see, the state pays us, but we work for our client. Really? And how do you do that? Do you tell your client the truth about the case, about the structure of the charges? Do you keep him 100% informed so he can make the decisions? Go, no, I don't want you going here and chasing these rabbits over here. I want you to go after the medical examiner who was a fraud, who had no authority, had never taken the oath, had never been appointed, is the one who brought the charges and who gave the devastating testimony against me, and and the evidence that he allegedly collected can't be verified to be true or not. I mean, how do you? I mean, if you don't undo that, how else can you proceed forward after that?
Right.
And then it just gets worse and worse and worse, because the alleged DNA samples and stuff collected at the autopsy and by the DPS were supposed to be sent to Rodney's, DNA defense expert. Oh, but who picked that expert? Well, it wasn't Rodney's defense team. It was the judge. And then how did Rodney come up with these two attorneys that represent him at trial? Well, it wasn't Rodney's idea. It was the judge's idea. Oh, I know this guy. And so that guy gets appointed and it says, oh, and I know this woman. And so then suddenly they get appointed, and they get their first piece of money 4 months before the trial.
Okay, so
Rodney's been sitting in jail since March, of 97. And no attorney has done anything until February of 98, and he goes to trial first week of May 98.
Okay, so the attorney gets paid 4 months before trial.
Right.
Cool.
And then
But they have to
go
do
ahead.
preparation. So
Oh,
why shouldn't they get
yeah.
paid?
Well, this was the first money that they were given to hire an investigator,
Okay.
and the first billable hour of work that they did.
Okay.
They didn't do any work. They didn't bill any work because nobody knew, who's the lead attorney, who's not, who's on first. It was like, Abbott and Costello, and it's never changed.
Okay.
And so what you have here is, is the state hiding a complete disaster. And, and until I was asked to look at a case by the local newspaper, nobody had given this case, a once over, with an investigator's eye, with somebody who understands how things work.
Now, this is also a phrase, or variations of it, that you have used since we met. You said people don't understand the way things work in Texas. They don't understand the law in Texas. They don't understand the Constitution in Texas. But you have all these players acting in this sphere, in this realm where they know nothing about it. Make that make sense?
Right. It's that attorneys aren't taught in Texas the foundation of our laws, the common law aspect of Texas law. If you don't understand common law, the foundation, the old British law, which our law comes from, then it's confusing. You have to understand the foundation of the law, why the laws say things they do, and to piece them together. Now, with me, this was all new to me too. Now, the statutes say one thing, and the court's rulings say one thing, and yet the courts are doing exactly the opposite. And see, that was what was so confusing to me. The rulings, back to the 30s and 40s and before, say that, and the statute says that the medical examiner is a judge because the medical examiner's powers come from the justice of the peace, which is a judge, who is who is in smaller counties and in the beginning did the death investigations. Now, his powers, he was a judge, so he had all the powers of any judge in the state, even, all the way up to the Supreme Court power, the judges of the Supreme Court, but actually was more powerful than the judges of the Supreme Court when it comes to death investigations, because they're basically God. And as such, their powers are that they can issue subpoenas, they can issue search warrants, they can hold people in contempt, they can set bonds, and all of these are the powers to do this death investigation. So in 55, when Texas created the medical examiner statute, they transferred all of those judicial powers, all of them, to the medical examiner. They created a judicial office. The medical examiner is a judicial office.
In Texas.
In Texas. And the statute states the duty of the medical examiner and their deputies is to conduct an inquest with or without a jury in all of the deaths enumerated under the statute. It also says that at the discretion of the medical examiner, if he believes an autopsy is necessary, then he shall perform it or order one of his deputies to do it. At the discretion. The autopsies are not required. The inquest is mandatory. That is the duty. And so what are the powers of the medical examiner when conducting an inquest? Well, he can, all law enforcement work for him. He can order law enforcement to do whatever he needs. He can issue a subpoena. He can issue a search warrant. He can issue an order to have witnesses brought before him in a courtroom where they are compelled to answer his questions, or he will hold them in contempt until they do. These are the powers of the medical examiner when conducting a death investigation.
Mm.
And if you don't, he can hold you in contempt. Contempt is solely a judicial power when handled by an individual. No other appointed or elected official in this state individually can hold a person in contempt. The legislature, the House, or the Senate can hold somebody in contempt as a body, but only a judge in Texas can unilaterally hold somebody in contempt. And so if a medical examiner under the statute can hold you in contempt, he's a judge. That is recognized as a sole power of a judge.
Do the medical examiners in Texas know this?
No, they don't teach them that because the DAs don't want them to know it. The Attorney General's office doesn't want them to know it. They are not taught anything.
But this is written in the Constitution.
It's written in the statute.
In the statutes.
And see, they're not taught. And so what they do is you've got Texas. They appoint a physician who's simply been a medical doctor all his life, and he takes a course in pathology and a fellowship in forensic pathology. And then they appoint him as medical examiner. He thinks, oh, okay, what are you supposed to do? Well, you do autopsies. Ooh, for what purpose? We'll determine cause and manner of death. Okay, well, the cause of death is a gunshot wound. The manner makes it a homicide because somebody shot him.
Mm-hmm.
So that's all I do? No. You're supposed to, upon the death, the beginning stages, if it's a shooting at a bar and everybody's in, at the bar when the shooting takes place, but nobody will talk to the police, medical examiner comes in and says, okay, I want everybody drugged down to my courtroom. I'm gonna open the justice of the peace, the county court of law judge's courtroom. And we're all going down, and we're going to hold an inquest. And one by one, I'm going to bring you in, and with my court reporter, and I'm going to question you. And you'll either answer my questions, or I will hold you in contempt and lock you up. But the first person who tells me what happens, and those that have refused, then they are co-conspirators after the fact. And you'll get charged. Well, you got 20 people, and they go, well, I'm not going to be the one to get, when I get called before the medical examiner and he asks me what happened, I'm going to tell him. I'm going to tell him where the gun is. I'm not going to take a fall for this.
Mm.
And everything gets solved immediately. But if you got a medical examiner who doesn't know that these are his powers and he can do this, and he's compelled to do this under the statute, then the medical examiner says, oh, just take the body to the morgue. No, I'll do the autopsy tomorrow.
But if you have a medical examiner that does that, though, what's the purpose of the other judges?
None. The JPs don't know it. They're not taught it. But the statute is real clear.
But that's what I'm saying, Fish. If the medical examiners are going to be doing this job along with doing autopsies, what are the other judges going to do? Because then they're not needed for any real trials because the medical examiner already took care of that when he did his autopsy and inquest. Yeah,
but see, what happens is now the police just, take the names of the people who are there, and they're released, and maybe 6 months to a year later, they'll get called before the grand jury to be questioned. Well, by then, everybody's already talked, decided who's going to say what, or they've forgotten what happened. And this can go on for years before it ever gets to a trial, and 90% of the evidence is lost. And so that's what leads to false convictions. and leads to murderers getting away. You see, it is absolutely the total bastardization of the system. And there's no justice, no nothing, for either side. For the family
Right.
of the decedent, or for, in a lot of cases, the person charged.
So the
And then
system itself is structurally sound.
it is absolutely sound. Our forefathers knew exactly what they were doing when they set this thing up. And see, what I had to do it once, when I started looking at this, I had to also go, okay, wait a minute. Is this system, as it's written, better than the system that
It's applied.
is operational right now?
Right.
Which one works better? I mean, is there a reason that they ignore what the statute says? Because if the system that they're using is better than the written statute, then we need to get the legislature to clean up the statute.
Right.
So I look and I go, no, the statute as it's written is near perfection. The way it's being run is total corruption.
Well, that's typically what happens when you add people.
It's what happens when sadly to say, you come from a state that goes, oh, I know Billy Bob. He's a good old boy. You can trust him. Yeah, that's the end of it. That's when the wheels go off. That's your recipe for a used car lot salesperson. Tell the public whatever you need them to know to get the job done. And then let the pieces fall where they may. My job's done.
Okay, so the medical examiner doesn't act in his capacity as a judge. He now becomes a
tool.
Yes. An expert witness based on his field of expertise.
And his field of expertise is just determining whether the person died from an act caused by another.
Mm-hmm.
It has, but the statute requires the medical examiner to collect the evidence to be used in the prosecution of the person who committed the crime. Medical examiners don't do that. Because if you have somebody who was shot, there are only two people involved, and you have the body and you have the person with the gun, so it says, oh, well, it's open and shut. It's a homicide, and the person who had the gun was charged with murder. Yeah, not so fast. You've got accidental shooting. You've got self-defense. You've got a homicide. There are lots of different reasons that people get shot and killed, and it's not murder.
Mm-hmm.
So
you mean like that what happened to Ed Salmon?
Yeah, like what happened to Ed. And so the medical examiner is charged with determining and collecting the evidence, as proof of what really happened. Now, in that a medical examiner is a judge, you know what he is not allowed to do in Texas?
What's that?
Take the bench in a trial. Take the stand.
Whoa. So
he absolutely cannot, under our system of government here in Texas, our system of laws, a medical examiner cannot be called as a witness. Period. You see,
by way of the statute, because he's a judge?
Because he's a judge. His duties are judicial. They are not subject to being challenged as a collateral attack under the jurisdiction of another judge. So the district court judge who's presiding over the prosecution has no authority to order another judge to take the stand to be questioned by either party or himself. All judges' actions under their authority are sovereign. And the only way that their actions can be challenged is through an appeal, through an appellate court.
Mm-hmm.
And that's what appellate courts are to do. They are to review, the actions and findings of a judge. No trial court can do this. And that's why in counties where the justice of the peace orders the autopsy and does the death investigation, you've never seen a justice of the peace put on the stand because they're recognized as being judges, and you can't do it. Well, medical examiners are judges too, and guess what? In January of 2022, the Commission on Judicial Conduct, based on that ruling by that special court of review set up by the Texas Supreme Court, now recognizes medical examiners are judges. Now, just because the Commission on Judicial Conduct now has been forced to recognize medical examiners are judges doesn't mean that, okay, from January 2022 forward, medical examiners are judges. But prior to that, they weren't. No, they've always been. Now, here's something that the Commission on Judicial Conduct told me. See, I found out about this because the Commission on Judicial Conduct called me and alerted me. Their general counsel, the attorney who represents the Commission on Judicial Conduct, called me and alerted me to this ruling and told me that now the Commission on Judicial Conduct, recognizes that medical examiners are judges, like I've been trying to say for 20 years. But here's something else that the Commission has told me in writing. Their authority over a judge has no statute of limitations. So Bayardo was a judge as a medical examiner, then they can reach back 20 years and slap him.
But wait, you're not a judge if you do not take the oath.
So, and see here comes all the, I've been maneuvering as I learned this stuff. Then you've got to get the statutes changed. You got to build a foundation because nobody's been playing by the rules. Well, when Rodney almost got executed in November 2019,
mm-hmm.
one of Barry Scheck's Innocent Project defendants got executed in 2019, Larry Swearingen.
Right.
And Larry Swearingen got executed because a retired judge who was appointed to his case, who refused and failed to take the oaths, signed a void execution order and had him executed. Now that constitutes a capital murder in Texas. And that judge is going to face that charge sometime in the not too distant future. Because remember, there is no statute of limitations on a murder.
Okay.
But that judge knew he had no authority to sign that execution order and did it anyway with the sole intent to have this guy executed. And that is a murder. Even if your tool is the state, it's still a murder. Now, by the time I realized it, it was too late. Now, Rodney was facing an execution in 2019 too.
Right.
Both Larry Swearingen and Rodney Reed were both represented by Bryce Benchett and Barry Scheck's Innocence Project.
Okay.
I had been warning Bryce and the Innocence Project since 2014 that Doug Shaver, the visiting judge in Rodney's case, had never taken the oath of office. And as such, his orders and his actions were illegal and void. So I took my eye off, Larry Swearingen. But I focused on Rodney, and when Doug Shaver signed the execution order, then I started watching him, and no sooner did he sign the execution order, then his name disappeared off the list of retired judges eligible to be appointed to a court bench, which told me he resigned or retired. And so I filed a records request to obtain that resignation notice. And when I got it and saw that he was feigning mental incompetency, that meant his order that he had just signed is void. He was going to let Rodney get executed on a void execution order. Just like what J.D. Langley was doing to Larry Swearingen in Montgomery County. So I turned over the records to Austin's Channel 36 KXAN TV, who then went public with the records, and the execution was halted. Now, when I realized what happened to Larry Swearingen, I went to the legislature and told them, they better fix this mess on these judges, executing inmates without authority, or I would in federal court, and they wouldn't like it. So, in 2021, when the legislature came into session, they put on the ballot what was known as Proposition 5. And Proposition 5 was an amendment to the Constitution to give the Commission on Judicial Conduct authority over judicial candidates. Now, that's not an attorney running for a judgeship. That is a judge who's been elected or appointed to a bench who has yet to take the oath. So until they take the oath, they're still a candidate for that appointment or election. Okay. So now the Commission on Judicial Conduct can go after a judge who is presiding on a court bench having not taken the oaths as a judicial candidate.
Now that was from that point moving forward?
From the passing of that amendment on around November 5th of 2021, now retired judges who don't take the oath can be stopped by the Commission on Judicial Conduct. Now, to show you how that works, in 2015, Rodney had his first execution order issued by Doug Shaver. I talked to Bryce, told him that Doug Shaver had not taken the oath, and as a judge, it is required under our rulings of our Supreme Courts that judges cannot be a judge of any stripe without first taking the oaths. Okay. And Bryce poo-pooed it, wouldn't take any action. So I turned to Quincy and tried to have Quincy do it, and nothing got done. So in 2015, on a Friday, I think it was like February 23rd, I filed a complaint with the Commission on Judicial Conduct against Doug Shaver and his execution order for Rodney in March of 2015, pointing out that he had not taken the oath and his assignment order was void because Doug Shaver was a judge from the 3rd Administrative Judicial Region, and Bastrop County is in the 2nd Administrative Region.
But he could have easily been appointed by the judge over that region.
There was no authority, and he had not taken the oath. Now, under the statute that covers visiting retired judges, if the Commission on Judicial Conduct starts an investigation of the judge, their actions are stayed pending the investigation. So that would stay Shaver's execution order of Rodney. That's why I filed it. So I filed it on a Friday. The next Monday, the Commission on Judicial Conduct halted Rodney's execution. And on Tuesday, I received in the mail notification by the Commission on Judicial Conduct that they had started 2 investigations, once against Shaver and one against the administrative judge who appointed him. Now, in a cover sheet, you know, with the particulars about the powers of the Commission on Judicial Conduct,
Mm-hmm.
there was a paragraph that stated, listed all the type of judges that the Commission had authority over, and a sentence stating that they did not have authority over judicial candidates. And see, that's the first time I'd ever seen that. But I recognized what it meant instantly.
Those who have not taken the
So
oath.
I know that judges have to take the oath, and if you haven't taken the oath and you're on the bench, you're still a candidate because you can't become a judge without taking the oath, which told me instantly, oh, crap. There's no chance of tagging and stopping Shaver, but it did stay the execution, and it actually turned out it stayed it for 5 years, almost 4 years.
4 years to 2019.
Yeah. So that was fine. Now, to make sure that I documented this, that Rodney's attorneys knew this, I asked Quincy to file a public records request with the Secretary of State for all of Doug Shaver's oaths back to 1999 when he retired. He did. And asked him to provide me a copy so I could verify the Secretary of State was telling me the truth on the oaths that they were providing or lack thereof. So he did. So I have Quincy, at the time that Rodney is set for execution, is requesting the oaths for Doug Shaver. And the Secretary of State says that there are no oaths for Doug Shaver since he retired in 99. And yet Doug Shaver's been sitting on almost 100 cases from 99 to 2014. All of them illegal.
Wait,
Several of them
you said
death penalty cases.
From 99?
From 1999 when he retired.
But he did, let's see, this email to Brenda Wilburn in 2019.
Yeah, she's the clerk for the administrative judge of the second or third region. Sykes is the third, so she's the second, so she was of the third with Judge Stubblefield.
Right. So in this email, he's saying, I have filed instructions to the Supreme Court to remove my name from the list of judges who accept assignments.
Right. But he's never qualified to meet the requirements of a retired judge. See, this is how corrupt the system is. All the judges are playing this game. In fact, we have a new scandal just broke out last week in Austin in a trial where this guy sexually assaulted a disabled woman.
Mm-hmm.
And they put him on trial. The judge who's presiding over the trial is a visiting retired judge, and one with a long track record, high-profile track record.
Right.
Well, the jury comes back with a guilty verdict, and they're going to have, they're going to do the punishment phase the next day. Well, the judge doesn't remand this guy into custody. Now he's convicted, and lets him walk out of the courtroom while he disappears, and he doesn't come back for sentencing. And he's on the run.
Mm-hmm.
Well, I know this visiting judge has not taken the oath. So I immediately file a public records request with the Secretary of State for this judge's oaths all the way back to when he retired back in 2010. And it's going to show this guy never takes the oath. And that means that the trial was a dog and pony show. It's worthless. They'll have to retry this guy. And they can't charge him for skipping out on his punishment phase because the trial was illegal to begin with. But since the police are out trying to chase him down, should they shoot him, trying to take him into custody?
Mm-hmm.
See what a mess that would be?
Right.
because the guy wasn't guilty of anything, because the judge knowingly was illegally on the bench.
But here it is. This is something that has happened recently. Now we're talking about something that happened back
It's
in
still going on to
98.
this day. That's the point. Nothing has changed. The judge, even though the Constitution has been amended, so the Commission on Judicial Conduct could go out and start stopping these judges, they won't do it. They want me to file a complaint. But our Constitution makes it very clear that the Commission on Judicial Conduct is a proactive agency. Their duty is to ferret out bad judges, not wait for somebody to file a complaint, but they're to go out looking for them. But they won't do it. You know what they told me? Oh, Dave, we have such a limited budget. I go, can't be any more limited than mine.
Well, this is true.
And so, I mean, you got a big office, state agency, investigators, appointed, members to run the agency. Me, it's just my cash, my pocket, my work. And yet I can find these judges hand over fist. And you can't find a one? So, this last session of the legislature got something else done. The legislature in 2023 amended the Texas Government Code. It's called Section 602, Administration of Oaths. And what they did is they added a number 3 to Section 602.007. That new addition says that all judges appointed under Chapter 74 of the Government Code, which controls all retired visiting and senior judges, must file their oaths of office with the Secretary of State in accordance with Article 16, Section 1 of the state's Constitution. So now the statute makes it very clear that if you're a retired visiting or a senior judge and you're appointed to the bench, you got to take the oaths and file them with the Secretary of State before you take the damn bench. That went into effect September 1st. This judge that was on this case that let the sex offender leave the courtroom after he was convicted, was appointed in January, February of this year. What do you want to bet he didn't take the oath? Even though now it's in the statute. And it's been required by the Supreme Court of Texas since 1876 and codified under a Supreme Court ruling from 78 that all judges must take the oath. Before they take without taking the oath, they cannot become an officer de jure or de facto, and all of their acts are null and void. So you can't become any type of officer in Texas as a judge without first taking the oaths.
So
and if you take the bench, you're a trespasser.
This isn't a new law. This isn't new legislature.
The one on the government code?
Right.
No, the statute is new, but it's not what it purports. It's not what people think it is, and it is. You see, there's only one level of judge that can be appointed under Chapter 74 who doesn't file their oaths with the Secretary of State. And that's a county court at law judge, a statutory judge. They file their oaths with the county clerk. But if, as a retired county court at law judge, you're appointed to a district court bench or a county court bench as a retired visiting or senior judge, then you have to file your oath with the Secretary of State, not the county clerk. All district court judges and above have always been required under our Constitution to file their oaths with the Secretary of State. But I've had so many attorneys tell me, Dave, I can't find anywhere where it says a district court judge has to file their oaths.
Mm-hmm.
Well, no, because district court judges and above are part of the constitutional structure of our courts. And the judicial branch of government is one of the three independent branches. So all state-level judges under our Constitution are required to file their oaths with the Secretary of State. So no, there isn't a statute, because the legislature creates statutes, and the legislature can't interfere with the judicial branch of government. And likewise, the judicial. And see, people don't understand the separation of powers doctrine of our state.
Well, the separation of powers goes across the country.
Right. But in Texas, the separation of powers doctrine is the strongest in the United States, stronger than the federal government separation of powers. Our separation of powers are mandatory. The federal government is not mandatory, but Texas is.
Got you. You see, that's what makes Texas so unique, because they're
we were a republic. We were a country
right.
at one time.
Right.
And our founding fathers, Sam Houston, and the others, they were representatives in the East and saw the corruption in the East. So when they came to Texas, they structured our government to try to undo those pathways that led to corruption, of the old English law in the eastern part of the country. So that's why they gave the powers to investigate a death to a justice of the peace, a judge of so low a level that they don't have to have legal training, because anytime you're trained as an attorney, then your mind is tainted by the beliefs of the state. They chose the common law, average man, justice of the peace to handle the death investigation. The good old boy that has not been corrupted by the state's belief in what the law should be or how the law should be handled. And that's why, our founders did this, is to keep the corruption away from the district attorneys who use that power to investigate deaths to go after their political enemies. They give Joe Blow down the street $10 to go shoot, Banker Brown, and then they pin it on the guy who's going to run against them in the next election. Charge him with the murder. Well, the DA does the investigation. What do you think's going to happen?
Then he gets charged.
Yeah, right. So they understood that. So district attorneys on the East Coast were too powerful. So they gave the power of death investigations to the common man. That from the town, the guy who goes to church with you, whose kids grew up, that you trust, not the elected official who's, building an empire to become governor or senator or president, and who's willing to climb over any body that gets in his way. So this is where Rodney, case falls into this.
Mm-hmm.
He was a black guy who dated white women. And not just any white women. He dated sisters, daughters of law enforcement.
Mm-hmm.
And at the time, that was it. And so Rodney had to be stopped.
Mm-hmm.
And he wouldn't take the hint not to date the sisters of white police officers and sheriff deputies. So he had to be removed. And then you had a cop whose white fiance, or not fiance at the time, ex-girlfriend, dated Rodney and got pregnant at a time where the cop didn't know that it wasn't his, and so asked his former girlfriend to marry him. And then 4 months down the line, when the girl gynecologist could tell her approximate time of conception, realized it wasn't the cops. It had to be Rodney's. And again, I'll tell everybody, Carol Stites told me herself over the phone that she was aware that Stacy was pregnant, knew that it was Rodney's child, and Stacy's mother wanted Stacy to have an abortion, and Stacy refused. And Stacy's mother and sisters know and knew and still know that Stacy was pregnant with Rodney's child, and that's what got her killed.
That with there being no talk of a fetus in the autopsy.
Well, that little funny little comment that she was not a Paris woman. And that word Paris is an odd word. And I've only seen it used twice by Bayardo in the 30 years he was acting as medical examiner. Now, I have gone through many autopsies of women who were murdered that had previous children.
Mm-hmm.
And he never used that term. But in 2 high-profile murders, he used that term, 10 years apart. One in 86 and the other in Rodney's case in 96. The 86 case was Michael Morton. Bayardo put that same phrase in Michael Morton's wife's autopsy, that she was a Paris woman.
Paris meaning?
Paris meaning in terminology, and knowing Bayardo, and see this is the key. You got to know Bayardo. You have to read his autopsies and know how his little mind works. And Bayardo would always put a little piece of truth, would put pieces of truths in those autopsy reports, but you had to recognize them.
So you're saying that he lies in his autopsies?
You have Paris and oviparous. Paris is an animal who bears live young. Oviparous is an egg layer.
Okay.
So Bayardo is saying that Stacy bore a living fetus at the time of her death. She was a Paris woman. Live birth. Living fetus. And that's the kind of game Bayardo played.
In the case of Michael Morton, his murdered wife was pregnant at the time?
But he didn't know this. And, I've tried to get people to talk to him about this little glitch in the autopsy, because I am 100% certain, based on what I have, the research that I've done, that his wife her killer was somebody she had a brief affair with and tried to break it off, and he killed her. And Bayardo knew it, and they hid it. And Michael Morton spent 26 years in prison for that game.
So, okay, he used it in the Michael Morton case, and incidentally, I had reached out to Michael Morton, trying to get him to come on this broadcast, and we connected, but then didn't. Weird.
Yeah. Everybody tries to shut that thing down, and see, I still run up against this. See, the county judge at the time of Michael Morton's wife's death was Bill Elshire. He was a county judge. He had, he had discovered that Bayardo, was not the medical examiner. But rather than come forward and put an end to it, he just continued the scheme on.
What do you mean he wasn't the medical examiner?
No, Bayardo was, his contract was for 1 year, and it was never renewed, and he was never appointed. Well, Bill Elshire was the Travis County judge in '86 when Michael Morton, was charged with his wife's death.
Mm-hmm.
The Travis County judge knew that Bayardo was not the medical examiner and could not perform autopsies for Williamson County, the county to the north, that this was all a scam, and he kept his mouth shut and allowed this to go on, until 1977. 2007. And see, I still have Bill, and see, I talked to Bill Elshire about this. And he confirmed that in particular, one of the things I confronted him about was the 1991 yogurt shop murders. And that Bayardo had told the press that Tommy J. Brown was under contract with Travis County to do autopsies for Bayardo on the weekends and the holidays. Now, Tommy J. Brown, that name might mean something to you, Kevin?
Yes.
He's the guy who allegedly did the autopsy on Ed Samala.
Right.
And just like the 4 victims in the Austin yogurt shop murders from '91, the autopsy report is typed in Tommy J. Brown's name, but the scribbled signature
is not
his. Over Tommy J. Brown's type name is Bayardo's. Tommy J. Brown signed none of his autopsy reports. There's about 300 of them from '91 to '98. None of them are signed. And so Bayardo told the press in the yogurt shop murders that Tommy J. Brown, performed autopsies on the weekends and holidays for him under contract. Well, the Travis County attorney says, no, there was no such contract. And Bill Elshire was a county judge when the yogurt shop murders took place in '91 and confirmed they didn't contract with anybody to do autopsies for Bayardo. Weekends, holidays, period.
Mm-hmm.
If Bayardo wanted to take off a few days, the bodies would still be there when he came back. If you want to take off a weekend, they'd be there Monday morning. You want to take off a few days for vacation, the bodies would be there in the refrigerator at the morgue.
Mm.
And yet, I still have Bill Elshire playing these games. I am working on a big case out in El Paso, where the governor's newly appointed Republican district attorney didn't take the oaths. And then with the secretary, when I challenged them, the Secretary of State tried to backdate the oaths and the documents and got caught. Now, a reporter did a story on December 17th of 2023, a pre-story, and confronted the newly appointed district attorney, Abbott's district attorney,
mm-hmm.
about these falsified oaths and backdated documents. And the district attorney gets all panicked and he says, it was the Secretary of State. The Secretary of State told me what to do, told me it'd be okay. Yeah, falsifying records is going to be okay. Falsifying your oaths that are still not valid to this day. Oh, yeah, that's going to be okay. And by the way, this guy's been looked at by the FBI and the Texas Rangers right now over his fraudulent appointment and oaths and potential bribery by our governor.
No.
And so in this article that came out December 17th, the reporter, I didn't know it, but the reporter talked to Bill Elshire, for an attorney's viewpoint on the backdating of the oaths and the documents.
Mm-hmm.
And Bill Elshire says, oh, well, yeah, technically, but, I don't think any courts are going to hold these oaths as being non-valid, because they're not valid. You have a district attorney. Our Constitution absolutely mandates that a district attorney who's appointed to fill the remaining term of an elected DA who resigns, our Constitution requires the elected DA who's resigned to remain in that office until the successor qualifies for the appointment, means takes the oaths. So the Constitution mandates it, but Bill Schultz says, no, it's no big deal. I mean, this is how squirrely Texas is, and this is how corrupt the judiciary is, and the state bar. It's keep the scam going, because if one wheel comes off, this state train wrecks.
Now, as we talk about corruption and keeping things going as it relates to the Rodney Reed case, there are a few documents that you had sent to me recently, and I wanted to touch on these before we wrap up tonight.
Right. So the first one I sent to you is a Texas Attorney General opinion in '96.
Okay.
And this Texas Attorney General points out that most appointed officials are de facto or de jure officers upon their appointment, whether they take the oath or not.
Right.
But not judges. The judges must take the oath before they can become a de jure or de facto officer. And without it, all of their acts are null and void. So, and that's from 1996, and it cites a case from '78. That's the Supreme Court ruling from '78. So, this is the Attorney General holds this out, and it's still the case. This is the same case that's cited over and over and over about judges taking the oaths. So, judges have to take the oaths.
Okay.
And since the Commission on Judicial Conduct now recognizes that medical examiners are judges, they have to take the oath. Well, Bayardo was never appointed, never took the oath. And it's Bayardo's autopsy, evidence collected, and testimony that put Rodney on death row, which was all perjured, all illegal, all void. Are you listening, Barry Scheck? Because if you're going to talk about an appeal, you go to the foundation where it started. And if it violates the Texas statutes, Constitution, and Supreme Court rulings, then this conviction was built on fraud and perjury. And no conviction can stand on, the foundation being procured by fraud and perjury. And that gets rid of all of the evidence, the DNA evidence, all of this collected, because, the whole structure of the case is based on Bayardo's time of death, which was bogus, evidence he allegedly took, testimony of finding spermazoa heads and tails that contradict what he actually wrote, that there, only that there was suspicious that he never saw any. But you start there. And the fact that the courts have long held that a justice of the peace has no authority to send a body out of county for an autopsy, and if they do, they can't pay for it. It's void. The justice of the peace in Bastrop County, as a judge, cannot send a body to another judge and tell them to do an autopsy, an inquest. It is illegal. It is not statutory. And if a JP doesn't, he may not pay for it because he had no authority to do it in the first place. And if you ordered something that you had no authority, it's the same as going into a house and seizing evidence without a search warrant. You can't use it in a court of law.
Right.
And so the autopsy on Stacy was a criminal offense. It was tampering with a corpse. It can't be used in a court of law. You can't use his testimony. You can't use the autopsy report. You can't use the evidence you collected off the body.
Which leads me to the second document that you sent.
Right now, I have to pull up and see what the second one is.
Which is Jillian
That's a
Beck,
2000.
2015. This was with regards to a records request, public information request.
This is where I filed a public records request in 2015 for the invoices from the DPS paying for shipping the evidence, just before trial from the DPS office in Austin to Rodney's defense experts in Ventura, California. Now, I challenged these records in 2002 as being bogus, that they're manufactured.
Mm-hmm.
And Airborne Express says, we never shipped those. We never picked them up. We never shipped them. So after going back and forth since 2002, for 13 years, I said, okay, let's just get to the nuts and bolts of it. So I requested the DPS for their invoices for paying for those shipments. If they shipped them,
mm-hmm.
they have no records of ever being billed or shipping.
Which was
paying for any shipments.
So this is Jillian Beck of ACN News.
Yeah, she was, Jillian Beck was a reporter with the Austin American Statesman. And I had her verify what I did. So I had her request them too, and she got the same answer I did. No records.
Now, continuing the same vein, this one here, records request, Carolyn Rivas.
Right. So based on the testimony and the what Carolyn Rivas's sexual assault in 1995. I went ahead and filed a public records because they introduced this evidence at the punishment phase of trial, except they really didn't. And so I filed a public records request for the DNA for the breakdown of the lab reports. They denied them to me. And the only way you can deny is the fact that it's never been given to the defense. Anytime you give a record in a case to the defense, then it becomes a public record.
Mm-hmm.
So this is telling us that they never provided that information to the defense. Really? Because Lisa Tanner presented, said, oh yeah, the LabCorp's report, linked Rodney with the sexual assault of Carolyn Rivas. No, they didn't. They didn't do Rivas. Rivas was his girlfriend, but they never ran the DNA. Yet they sent it to LabCorp. Curious.
Mm-hmm.
So the results must not have come back to what they wanted it. So here's another piece of evidence that was used against Rodney, where they never produced to the defense the results of LabCorp's tests. Their results. And these were done just before trial.
Another document here is the no chain of custody.
Right. This is Jimmy Fennell's pickup. The story was that, they found the truck in the high school parking lot. Bastrop police officer Paul Alexander cruising the parking lot, about 5:30 in the morning, saw the pickup parked there next to the railroad tracks in the back parking lot of the high school, cruised over, got out, shined his flashlight in the pickup, Notice a broken piece of belt buckle on the ground outside the truck. What appeared to be bags of clothes in the back in the bundle seat,
Mm-hmm.
and books on the front passenger floorboard. And checked the truck and left. Made a report, notation, had the, license plate run, and left. When Stacy was reported missing and they made the connection and came back to the truck around 8 in the morning, the clothes were gone. They weren't in the pickup anymore, which means who was ever planning the crime scene was still there. The bags of clothes were in the dumpster on the other side of the parking lot. Taken into custody and never mentioned again. Now, after that, the pickup was taken to the Basco, wrecker facility,
Mm-hmm.
where it was held and doors opened with Fennell's keys and pictures taken to the inside, and then loaded up and taken to the DPS in Austin. And right as the Ed Somala and the tow truck arrived at the DPS lot, they had an officer run out and tell him that there was an emergency phone call for him and not to process the truck in and take the phone call. So Ed Somala goes in, takes the call. He's told by the Rodney Duncan, the police chief, they found a body and that he's to lead the DPS crime lab to the crime scene out on 1441. So they leave the truck there. Well, they claim that they processed it in and everybody looked at it and before they drove out to the crime scene,
Mm-hmm.
but nobody logged the truck in. The truck was never logged into evidence or into the facility as the DPS taking charge of the pickup that afternoon. And then 3 days later, according to internal records, they released the pickup to Bastrop. Apparently to Jimmy. But they said that was 3 days later. But on the reports during Rodney's trial, it says that Jimmy Fennell's truck was released to him 6 days later. The actual Carfax report on the pickup shows that it was sold to Gold Chevrolet in Giddings the very next day, on the 24th of April. So wasn't at the DPS lot, but when you ask for chain of custody, the Will Young, the head of the processing unit, who's supposed to log the truck in and out, says, "Oh, I forgot to get the officer to sign when we released the truck." So no records the truck was ever logged in or logged out. No chain of custody on the truck.
Mm-mm.
Kind of odd.
Not really surprising, but yes, kind of odd.
Well, yeah, you look at it, it's all this way. Everything. One after the other, after the other, after the other.
There was another document, new judge assigned to hear pending Rodney Reed motions. This one was from 2019.
Yeah, this is J.D. Langley. After Doug Shaver signed the execution order and then said, "Oh, I'm senile. I'm mentally incompetent. I'm afraid I'm going to make a major mistake on a major case. You need to take me off being a judge ever again." And the Chief Justice of the Supreme Court says, "Yeah, done."
Oh,
but they're going to go ahead and let Rodney be executed on that signed execution order from a judge who's been removed from office as being incompetent. So guess who gets appointed? Oh, J.D. Langley. J.D. Langley is the judge who executed Larry Swearingen in 2019 having not taken the oath of office, just like Doug Shaver. And remember, Larry Swearingen was represented by by the Barry Scheck's Innocence Project,
yes,
and Bryce Benjett and Quincy McNeil. Well, I don't think Quincy was actively working on Swearingen case, but Bryce Benjett was. And so Barry Scheck's Innocence Project and Bryce Benjett were going to let both Rodney Reed and Swearingen both be executed on execution orders by fake judges with no oaths until I stepped in and stopped Rodney's the second time. And so J.D. Langley gets appointed, and guess what J.D. Langley doesn't do when he's appointed to Rodney's case? He doesn't take the oath.
Take the oath.
And no, then he sits on the evidentiary hearing in 2021, 2022, and rules against Rodney, even though I've repeatedly told Barry Scheck and his minions that are holding this hearing, and including Quincy McNeil, that J.D. Langley has not taken his oaths to preside over this case. Now, the courts have ruled on these visiting senior judges that are appointed to preside over a case, that a defendant cannot challenge them on the trial level.
Right.
The first time you can challenge a judge is on appeal. Now, so as soon as J.D. Langley, filed his report, with the Court of Criminal Appeals denying Rodney's motion for a new trial, that's when Barry Scheck and them filed the appeal with the Court of Criminal Appeals, pointing out that Langley lacked jurisdiction to preside over the evidentiary hearing, and his findings are absolutely null and void. That's when you raise the attack, is the first time on appeal. But guess who doesn't? Barry Scheck wants to go and say, oh, the state lied to us and they didn't tell us that all these people knew that Rodney and Stacy were having an affair. Well, that is absolutely true, but it doesn't mean that Rodney couldn't have killed her. You see, that's the catch-22.
Right.
This doesn't affect the finding of the evidence that they've manufactured that says, oh, Rodney's DNA is on her, and he's the only person that could have killed her.
So your argument that the Innocence Project is ineffective at best, yes, they have mounted an argument, but they have mounted an argument that doesn't hold water.
They know will not change anything. They're simply wasting time, running the clock on Rodney, and putting up fake arguments, to say, oh, we're fighting as hard as we can.
Well,
yeah,
pretty much because they don't think...
It's just like Thanksgiving Day when you have the turkey and you go, oh, I love you, turkey. Come over here and lay your neck on the block.
Right. You you have been presenting...
It is that bad. It is that bad. And this is what they've always done.
Right.
This is the same thing over and over and over and over that Bryce Benjett from the Texas Defender Service to the Innocence Project has done to Rodney. They have thrown up there specious arguments that just fill time, that are easy for the courts to reject as they march Rodney, to his execution.
But for the most part, it does appear that they're putting up a united front in defense of Rodney Reed.
Right. If you don't understand the law and the rulings of the courts, and the bottom line, the fact that the state hid the fact that Rodney, if they did in fact hide, that they can prove beyond reasonable doubt that the state knew that Rodney and Stacy were having an affair and they hid it,
Mm-hmm.
does it mean that Rodney didn't kill her? And
Right.
see, you got to remember, he was convicted by a jury.
Mm-hmm.
And it wasn't convicted based on him knowing or not knowing, because the jurors even acknowledged that they believed that Rodney was having an affair with Stacy.
Mm-hmm.
See, they acknowledged that. They changed their mind after they found out that David Lawhon was brought to the court when they were not supposed to know that he was there taking the fifth.
Right.
But when they took David Lawhon out of the court, instead of taking him back out the jail door,
And they walked him out
they
the front.
took him out the jury room door, where all the jurors are lined up in the hallway ready to come back,
Right.
onto the stand. And they march him in his in his chains and his overalls, and all the jurors knew who he was, and because I talked to one of the jurors. And they said, yeah, they all said, well, apparently David Lawhon didn't kill her. And that's when they started looking at Rodney.
Mm.
So the jurors believed from the beginning that Rodney and Stacy were having an affair. So the state denying it didn't change anything. It was then that they undermined the juror by showing them that David Lawhon had testified and was now being led away, so he must not have done it. That is manipulation, and that's grounds for a new trial, except that won't ever be raised by Barry Scheck in the Innocence Project. Just like the fact that there's no proof that they ever sent the DNA to Rodney's defense expert. And when you look at this, Elizabeth Johnson, people say, well, Dave, it's Rodney's defense expert. Why would they challenge her? I mean, why would she do this? Why? Well, it's very simple. Rodney's DNA defense expert got her start at the Harris County Morgue in Houston, the very place that Bayardo came from, and the very morgue that lied to Travis County about Bayardo's credentials and his position in Harris County. They said that Bayardo was the deputy chief medical examiner in Harris County in 78, and he'd been a deputy medical examiner the year before that, from 76 to 77, and the deputy chief from 77 to 78. Well, the truth is, Bayardo was never a medical examiner in Harris County, period. But he was related by marriage to the chief medical examiner, who's the one who lied to Travis County to get his boob incompetent in-law a job in Travis County. And this DNA expert got in trouble and was accused of tampering with DNA evidence in Harris County. So that's interesting. Plus, in 98, the Galveston County District Attorney tagged this DNA expert, Elizabeth Johnson, with tampering with DNA evidence and not testing the evidence that was sent to her in a murder case there. And the way they tagged her is she was a DNA expert for the defense. They sent a bunch of DNA evidence for her to test, and then they're coming up on the trial, and the district attorney says, I want back the DNA evidence that she tested where she didn't use up all the sample in case we have to retest this stuff based on her testimony. So he contacted the DPS and told them to request all the unused up evidence to be returned. And when it came back to the DPS crime lab, they contacted the district attorney and said, hey, these packs hadn't even been opened. She didn't run any tests. She gamed them just like she did Rodney. Now, you get one time at this. Now, when Kobe Bryant was accused in Colorado of rape in 2000, 3, 4?
Yeah.
Well, I was consulting with the prosecuting's office. Kobe Bryant's DNA expert was Elizabeth Johnson. I'll tell him, yeah, better be careful with this. Here's what you need to do, and here's what you need to get, because this woman will lie. And what she was telling everybody in the press was she could prove that the victim had had sex with several men that night, not just Kobe.
Mm-hmm.
Well, when they finally got her in a deposition and asked the questions as I kind of formed it out for them on how to go after her, well, guess what? The whole thing fell apart, and within a couple of days, Kobe Bryant cut a multi-million-dollar deal with the victim to drop the charges. Because his DNA expert got caught.
The same DNA expert that...
Same DNA expert that Rodney had, the same one that tried to tamper with the evidence in the Galveston County case. And, oh, guess who she's the big DNA expert for? Barry Scheck and the Innocence Project. So why do you think they're not challenging the scam she pulled in Rodney's case? You see,
right.
The Innocence Project has a conflict of interest. Do you think they're going to tell Rodney? Tell the courts? That if they go after Elizabeth Johnson for being a fraud, it could affect the other cases that they've hired her to do. And since she's got a history of not telling the truth, yeah, which side of that coin do you want to fall on? Trust her? Not trust her.
The last document that I want you to address is the one requesting the statements of office and oaths for...
what's the date number on that? 2019 or 20? Huh?
21.
21, okay. Click that one, open it up. Yes, this is my public records request to the Secretary of State seeking the oaths of J.D. Langley. My request is I'm asking for his oaths that he would have filed from January 1st, 2014 to July 21st, 2021. Now, this is after Barry Scheck and them filed a mandamus to remove J.D. Langley. Now, just to make this clear, the Supreme Court has already ruled in the past back in 1998-99 that you can't file a mandamus to remove a visiting judge. You can only file a writ of quo antro, and that can only be filed by the district attorney, county attorney, or the attorney general of the state. Defense can't file a writ of quo antro. So anyway, what the state comes back with is they give me a statement of officer, which is better known as our anti-bribery statement, filled out by J.D. Langley for December 31st, 2014. Another one for 2016. Another statement of officer filed November 27th of 2017. And one for December 3rd, 2018. And the last one, December 2019. Now, this is right after J.D. Langley in November 2019 is appointed to preside over Rodney's case. No oaths of office. Now, what an anti-bribery statement says is, and by the way, look at that last one that he filed.
That's a 2019 one?
Notice there's no state seal for Texas.
Right.
And notice there's no place above his signature where he swears under penalty of perjury. Go up to the 2018, and that one doesn't have it. Go to 2017, and you've got the official statement of officer with the state seal. And just above his signature, it says execution under penalties of perjury. I declare that I have read the foregoing statement and that the facts stated therein are true. And what he's swearing to is, and I got to blow this thing up so I can see it because I got a compressed copy. What the statement says is, I, J.D. Langley, do solemnly swear or affirm that I have not directly or indirectly paid, offered, promised to pay, contributed, or promised to contribute any money or things of value, or promised any public office or employment for giving or withholding a vote at the election at which I was elected, or as a reward to secure my appointment or confirmation, whichever the case may be, so help me God.
Mm-hmm.
This is called the anti-bribery statement. You have to execute this and record it before you can be sworn the oath of office. It's the oath of office that conveys any authority. The statement of officer is only required that you swear that you didn't get the appointment or the election by hook or crook. Only after that is executed and recorded with the Secretary of State can you take the oath. But you notice he's never taken the oath.
So the records request, let me go back up to the request. States, please find my email, blah, blah, blah. The statements of officer and oaths of office for retired senior judge J.D. Langley, filed with your office from January 1, 2014 to July 21, 2021.
Never taken the oath. He became a retired judge in January 1st, 2014. So he's never for any appointment or assignment to a bench has he ever taken the oath. And that includes Larry Swearingen case, who he had executed in 2019.
I just wanted to have you clarify this, and so that, because, you know, there are people that will come on this broadcast after the fact and make certain statements, comments on whatever was said. Now, if they want to say that you left out the oaths, and you got the statement of officer and the oath, and you just left out the oaths, I encourage anyone who has that argument to present to me the same type of information here.
Just file a public records
request
for the Secretary of State asking
Right.
for the statements of officer and oaths of office.
Right.
Now,
present to me what you have received.
Yeah, and you see, this is what the district attorney, Abbott's appointed district attorney in El Paso, did. He was appointed on December 14th, 2022. He then had the official oath of office sworn to him on December 21st of 2022, and then took the office and started performing the duties of a district attorney. Now, on December 30th of 2022, I filed a public records request with the Secretary of State requesting his oaths for the period of December 1st, 2022 to December 30th, 2022. I wanted Abbott's newly appointed Secretary of State to produce those oaths. Well, she came into office on January the 5th, 2023, and didn't provide the documents until February the 8th, 2023, over 30 days later. You have to respond in 12 days. Since there were no oaths on file, she should have immediately responded, by January 15th, 2023, there were no oaths. But she didn't. When she responded on February the 8th, 2023, she provided the oaths of office from Bill Hicks, file stamped, dated January 11th. So she withheld this information until she got the oaths. Now, that told me that she had to have contacted him. So I immediately filed a public records request for her email communications with the appointed DA over the oaths. And I got those, and it showed that she didn't contact him until January 25th, 2023, that he didn't file his anti-bribery statement. And without the anti-bribery statement, he couldn't take the oath. The oath he took on December 21st, 2022 is void. No authority. So he emailed her the statement of officer on January 26th, 2023, and she backdated the file stamps to January 11th. Now, that's a felony, third-degree felony, for the email communications for fraud and to falsify those two oaths and backdate them. Those are third-degree felonies. On top of that, the oaths that he produced for the office of, that he was appointed to,
Yes.
it just says district attorney. There's no such office in Texas. He was appointed to the 34th Judicial District Attorney's Office. It covers 3 counties: El Paso, Hudspeth, and another one, Culberson. The statute requires that you must be specific as to the office you're appointed or elected to. So the oaths on their face are void because it doesn't specify a legal office that he is allegedly appointed to. And those have never been corrected. And this is the foundation of the criminal complaint that has now been filed with the FBI and the Texas Rangers involving Abbott's appointee as a district attorney of El Paso and Abbott's newly appointed Secretary of State, who conspired with him to falsify his records and submit those to the Texas Senate for confirmation. It also means that the Democratic DA that was forced to resign from office under our Constitution is still the holdover district attorney of El Paso until this appointee files a valid oath. And she's entitled to all the power and compensations and privileges of that office. He, on the other hand, who's been accepting a salary for over a year and a half now, all those monies have been illegally procured by fraud. He has to pay them all back. See, there are consequences to this kind of crap.
But who is going to enforce all of this?
Me. What I did is I nailed the county commissioners. I went ahead, put the files together of all these falsified documents, and sent them to the El Paso county judge, commissioners, and county attorney, and told the county attorney she has a duty, under the statutes, to file a writ of quo rantro to remove this appointee, Bill Hicks, as an impersonator and trespasser on the office of the El Paso district attorney.
Now, how does this action affect Rodney?
Rodney, indirectly, the oath issue coming up there on an official for the first time being challenged, that rolls and opens the doors for these judges and Bayardo. You see, once this stuff starts rolling, it takes on a life of its own. Because if a district attorney didn't file his oaths properly and thus is removed from office, what do you think it does to the judges, which the medical examiner is as well? Because the district attorney is part of the judicial branch of Texas government. And if a district attorney doesn't take his oaths and is illegally in the office, and the district attorney is part of the judicial branch, that's why they're appointed to the 34th Judicial District.
Mm-hmm.
District and county attorneys in Texas are judges, are part of the judicial branch. They're not judges in themselves, but they're members of the judicial branch of government. Now, because the district attorney hasn't filed a valid oath, he has no authority to take cases to the grand jury because he's not the district attorney. He has no authority to go to bond hearings. He can't prosecute. Everything this guy's done since December 21st, 2022 to this date is a fraud on all of those defendants and a violation of those defendants' U.S. 14th Amendment rights to due process and equal protection under the law. So that's federal. Now, what I did by throwing it in the face of the county attorney and the county judge and commissioners, they then went to the FBI and to the Texas Rangers, not me. They did.
Mm.
And the general counsel's office confirmed that to me last week in writing.
Got you.
So now the press has that, and they're getting ready. Plus, I was told, contacted by an El Paso judge, that they're all aware of this criminal investigation. And see, this appointed district attorney by Abbott told the press that now that he's announced that he's going to run for a full term this November, full 4-year term,
Yes.
that he's running as a Republican because it's understood when the governor appoints you that you run under their banner, under their party. That violates the anti-bribery statement. Oh, no, no, no. There can be no conditions to that appointment. But Abbott just this last October, 2023, appointed a new district attorney in Corpus Christi.
Mm-hmm.
And that guy told the press that Abbott appointed him. He's a Democrat, hard Democrat, which really TO'd the Republicans in Corpus Christi. And so a couple of Republicans are running against him in the primary. Well, this guy told the Republican precinct chairs that he was running as a Republican, even though he's a Democrat, because it was part of the deal, which means that Abbott wouldn't have appointed him the district attorney until he agreed to run as a Republican for the office, which is, that's bribery.
Yes.
And he told this is published in the press. This is not a good deal. And on top of that, he also made comments that if he didn't do what he was told to do, that'd break his arm, which means
so he's threatened on top of it.
Yes, that the people who recommended him and the governor to give him the appointment are telling him what to do, which is what I have been hearing, from appointed officials for over a decade about Abbott. And so here we go. So, yeah, it takes, Texas is so corrupt. It truly is so corrupt. People who are moving to this state do not understand. You're moving to a state that's constitution and statutes are only as good as what the current governor and attorney general, or judges deem that you should have.
Right.
What is written is pliable. You have no rights in this state other than what the officials who are presiding over you at the time decide you have. And that's the truth of it. And that's why Rodney's in the position that he's in. But this is getting a little shaky here, and the legislature is getting very nervous about these judges, and so they have been building, the foundation to take this scam out.
Well, we have a little bit of time. Let's see how this plays out.
Right. Well, see, I've already done some other preliminary foundation building that would make it near impossible for J.D. Langley to sign an execution order, or for another retired judge to be appointed to Rodney's case. This is going to have to go back to Carson Campbell. And, I'm to the point I've had enough of the Innocence Project. And it may be getting time to file an action against them and document it.
Ineffective counsel.
Ineffective assistance of counsel is minor. Actual willful corruption and conspiracy to violate Rodney's U.S. 14th Amendment rights of due process, equal protection under the law, and honest judiciary, because the Innocence Project are crosswise with Rodney's interest. Rodney's interest rests on exposing Elizabeth Johnson having not tested the DNA, that it wasn't Rodney's DNA that the state is using again as his right now in the filings. It's the DNA. Rodney's DNA is actually that of David Lawns, and the DNA they're using for Stacy is Marianne Alt, because initially that's what the DPS and the Texas Rangers, that's where they were going, is to charge David Lawhon with the murder of Marianne Alt and Stacy at the same time. And they did this all through 96. It wasn't until 97 that they had to change directions, because David Lawhon wouldn't plead in his plea deal to killing Stacy, only Marianne Alt. But see, they set it up that David Lawhon killed both of them, so they have to be using David Lawhon's DNA for both of them, right?
Stands to reason.
Yeah, and so, they can't use David Lawhon on Stacy's on that mixture, because that won't work, because it won't match with Rodney's. So they have to have both the alleged perpetrator and victim have to have unified DNA mixtures, and the only way you get that is David Lawhon and Marianne Alt. You just simply change the names to Rodney Reed and Stacy Stites.
But all they have to do is just double check the DNA.
I have told them, now that they've done more extensive testing, DNA testing, so all you got to do is get, Richard and Ryan's and Roderick's, the other brothers' DNA, and run them on a paternity test against that they're using for Rodney, and it won't work.
But even so, just do an independent test.
They will tell you that.
With
Wait
Rodney's.
a minute.
Why not? Why not just do an independent test with Rodney's against what they have as evidence of Rodney's?
Right, the numbers that they're using, they could do that too. But you see, Rodney's incarcerated, and you don't have access to get Rodney's directly DNA blood from him. You'd have to go through the courts, and the courts wouldn't allow it. So you have to go to the brothers.
Okay.
And use the brothers to show there's no family match here. Because remember, at the trial, Lisa Tanner, confronting Elizabeth Johnson on the stand, stated, this is in the trial, she says, would it surprise you if we told you that we obtained the blood of Rodney's dad and 3 brothers? Wouldn't that confirm our numbers, like 1 in 10 billion being Rodney? You know what Elizabeth Johnson said in answer to that?
I actually didn't know.
I didn't know that. And that's a Brady violation. That was withholding evidence, because now the numbers that the state put in are now non-supported, because you got additional evidence and you didn't produce it
with the defense.
So the defense could verify your numbers. That's just the first step. But they never ran those samples. You see, they never tested them.
Right.
Because they know what would happen if they tried to do that. See, all of these tell you that all of these little pieces tell you there's something wrong with the DNA that they're alleging to be Rodney's and Stacy's. Because if they were using Rodney's, they had to run his brothers and his dad just to drive the numbers home.
Right.
If they were using Rodney's DNA. If they weren't, they wouldn't touch them with a 10-foot pole. And they never tested them. And see, this is because they collected this evidence, and Lisa Tanner addressed it and said that suggesting they had tested it and to verify the numbers of Rodney of 1 in 10 billion or 20 billion or trillion or whatever the numbers were. Then the defense has the right to have those samples to run them themselves.
And they still haven't gotten it.
But they have access to Rodney's brothers to take their blood and verify what the state gave them you see.
Which further supports your argument that they're not doing anything to help Rodney.
No, they're absolutely not. Because if you're going after this thing, again, just on common sense, simply because Rodney and Stacy were having an affair doesn't mean they could have gotten in a fight and him killed her.
Mm-hmm.
The fact that the state didn't release evidence that they knew that Rodney and Stacy were having an affair doesn't change the fact that Rodney was convicted on the DNA evidence and Rodney stating that he didn't know her. See, that little trick that David Board played that first day on Rodney, you know, that you see in the totality of the picture. You have to always look at the full picture. Because only when you look at the full picture can you see how well laid the scheme was and where the holes are to exploit. And see, Barry Scheck and them are not doing this. And they're supposed to be experts at this. Innocence Project, I mean, all the money in the world, all the students and you know, professors and everybody, all the best brains in the world, and yet they can't do one common sense thing? See,
common sense is not so common, Fish. Common sense is not so common.
Yeah, yeah, I'm beginning to, more and more you see this. Yeah, common sense is only common to people who have sense.
Us commoners.
But anyway, like I said, you know, Barry, this if this was just incompetence, that'd be one thing. Right. But Bryce Benjett made a comment to me early on, back 2003, 2004, about 2003, maybe 2002, 2003, when I was meeting with him and providing some additional records. And I met him in person. And he got all excited and says, well, Dave, you know, we think we can work with this new Attorney General, Greg Abbott. And I go, what do you mean work with him? Well, you see, you know, the Texas Defender Service, we have clients, you know, death row and, you know, inmate clients that we know are guilty. But the state has a weak case, you know, and we can beat them in the courts. But at the same time, you know, the Texas Defender Service, we have clients that we know are innocent, and yet the state has the best case. So it's believed we can trade with Abbott, that we won't push to overturn the conviction of somebody we think is guilty in exchange for the state, you know, not pushing to, you know, on the conviction on people we believe are innocent. And this has become very clear that the Innocence Project, as with the Texas Defender Service, cut the deal with the state, that both agree that Rodney's guilty and the Defender Service won't raise any issues that could overturn his conviction. And we're seeing that in real life over and over and over and over and over again.
Several times, yes.
Yes. And so that can only be that deal that Bryce Benjett told me about back in 2002, late 2002, early 2003, when Abbott became the Attorney General. And see, now all of a sudden it all makes sense, doesn't it?
Yeah. But it had to take 20 years, though.
Yeah. Huh?
It had to take 20 years, though. This is not something that would just show up in 3-4 years.
The 20 years since that was told to me, the record is consistent. There's no deviation. The Texas Defender Service, and then Bryce on his own, and then with the Innocence Project, all over and over and over and over. They won't challenge the judges who are unconstitutionally on the bench. That all of their acts are void. They won't raise them on appeal. They won't raise them anywhere. They let them sign execution orders and then stand aside twice trying to get Rodney executed. Twice. And they succeeded in doing it with one of their other clients.
Right.
And then they let the same judge who did that get appointed to Rodney's case. Now, here's something interesting. Guess who appointed Langley, requested that Langley be assigned to Rodney's case?
Shaver?
Back in 2019.
Who
Doug
did
Shaver.
it?
Doug Shaver.
Which was what I asked, if it was Shaver.
Yeah, Doug Shaver. 2 months after the Chief Judge of the Supreme Court had removed him from ever being a judge again in this state because of incompetence. But you see, after I filed a public records request, actually it was a Rule 12 request, which is a judicial records request,
Mm-hmm.
asking for the assignment order of J.D. Langley to Rodney's case, and I received it. I didn't know until 2021 when I was going through my file, and I realized I didn't request who requested
Mm-hmm.
the assignment of another visiting judge. So I file that, and I get back from the administrative judge that it was Doug Shaver. Filed a request with the former presiding judge asking that a new visiting judge be appointed to Rodney's case. You can't do that. Only the elected judge of that court, which is Carson Campbell, can request. Once Shaver is gone, the case reverts back to the trial court unless there's a conflict of interest. Well, there's no conflict of interest because Carson Campbell was not part impartial of Rodney's conviction or anything else, or did he ever represent Rodney as an attorney? So Carson Campbell is the only judge that can preside over Rodney's case. But once what they did, when I looked at the dates, I realized that it was when I requested the assignment order, they realized that they didn't have a request for Rodney to be assigned. And so they went to Shaver and had him do it.
You know what? Listen, we got to wrap up. So
Yeah.
with
Yeah.
with that point, with that feather in the hat, we're gonna let those who are the legal pundits and the ones that have the wonderful opinions do their homework on that bit and then come back, because we know there'll be some comments somewhere along the line. Every time you're on this broadcast, there's a slew of comments on the YouTube post, and I'm fine with it. I encourage the rebuttals. I encourage the questions. I encourage the presentation of other material. As long as you are, one, respectful with it, and two, you're presenting it in a similar format as it was presented to me, and I'm presenting it on this platform right now. Outside of that, don't just tell me, well, this, whatever, the cow jumped over the moon, and you're not presenting me with the documents that support it.
And so that everybody knows, I'm open to, to anything anybody can provide me, because every now and then somebody provides me a document that I wasn't aware of. But what I do, and the state knows that I do, I'm meticulous about the paperwork and the documentation. I have
Right.
no interest in trying to say, oh, well, this is true when it's not. That doesn't further my interest, my reputation, or Rodney's guilt or innocent. I mean, there are people that do this, and I've never understood why. It's simply foreign to me.
Mm-hmm.
You tell the truth, and the truth has to stand on its own. You don't try to twist it. You don't try to manipulate it. It is or it isn't what it purports to be. And that's always my position. If I had seen stuff or seen anything that led me to believe that Rodney was guilty, I'll tell you. Problem is, everything I see and my dealing and knowing how things work, and I've been doing this for continuing to go on, and the state, I mean, it's every trick in the book. It's hook and crook, whatever it takes to get the conviction. Well, now that Lisa Tanner and Mitzi Wolf kind of hung themselves by bringing, perjured evidence before Rodney's evidentiary hearing and got tagged and got popped out of there, it's gonna see, interesting to see who they would try to prosecute this again. But what I think they're going to do, what they're doing now, is they're preparing, because people need to understand that are supporters of Rodney. The Court of Criminal Appeals will not stay in execution because there's some hearings pending before the U.S. Supreme Court. you see, the U.S. Supreme Court doesn't have a lot of authority over states' rights on this issue. If the state wants to execute Rodney, they'll spit in the eye of the federal Supreme Court, because what's the Supreme Court going to do? So people have to be cognizant of that fact, and that's why Kevin and I are talking about it, because we both sense that they're getting ready to go at it again.
Yeah, something's brewing.
Yes, and this motion that was filed this last December that you can read on Rodney's Facebook page.
Yes.
That is something that absolutely the Supreme Court will not stay an execution order over, nor will the state. In fact, that more likely encourages the Supreme Court to strike it down.
Mm-hmm.
Because it doesn't prove anything.
Right.
That goes to innocence, guilt or innocence, or perjured conviction, or anything along those lines. So anyway, yeah, we'll need to curtail this. Kevin, you got to get some sleep.
Yeah.
I still got some paperwork to do.
I can tell you, this man never stops. I don't know how he does it. He never stops. But I tip my hat to him each time, because anything that he says, he has the documents to support it. Now, you can argue that he manufactured the documents. Go right ahead and do the same thing he did and see if you got the same results.
Yeah, then what you can do is so people understand, you don't have to file the same public records request that I file to verify me. You can file a public records request for the public records request I filed in the results. So
right.
You can get the state to produce those same records that you're seeing by filing a public records request for my public records request and the documents that the state produced. See, that's how that works. You
right.
can do that too. If you want to see, what I requested and what they sent me, you can request my records request and what they sent me.
Right.
So that's how simple it is. That's why I would be more than a fool, or what we'd call an Aggie in Texas, to try to do this, to falsify the records, because you can just request my request in my records. I mean, if I
right.
falsified anything, boy, you would have that in black and white right fast.
Right.
Less than, a little over 10 days is all it takes to get those. So after you file a request, they got 10 business days. They have to have your response to you within 10 business days. So anyway, we'll wrap it up with that.
Yes, sir.
And stay in touch, Kevin.
Definitely. Thank you once again, Fish.
And thank you for everybody, and a big shout out to Donnie Walker.
Yep. May his soul rest in peace.
Yes.
Listen, take care of yourself. Thank you once again. We'll talk.
Thank you much. I'm signing off. Have a good night.
Good night.
Bye-bye.
Lost in delusion, and now they reside.
Nikki Blaze says, listen, I see them lost in illusion.
My race remains poor.
I see them wrapped up in this whole web of corruption, deceit, and I don't even know what else.
My race that built this great nation.
But as long as we step up, stand up, and let our voices be heard when we see corruption, when we see a mishandling of justice, when we see the misrepresentation of information, then we end up putting ourselves in better positions. We end up putting those that come behind us in better positions, which is exactly what we need to do. Ladies and gentlemen, thank you for your time. Thank you for listening in. Thank you for those who shared. Thank you to my affiliates. Truly appreciate you. Thank you to my sponsors. I didn't mention them at the beginning of the broadcast, but you saw each and every one of them pop up right here. And I thank you all. As we move forward, we look to encourage each other. I look for your encouragement as I try to encourage you all in moving forward to have acceptance through enlightenment. You don't have to agree. You just have to understand. And that's what we strive towards. Understand that corruption exists. And it exists at all levels. You would never think that a state would go as far as they did. But we see it time and time again, which is why wrongful incarcerations exist, which is why wrongful executions exist. They don't happen in a vacuum. They happen right here in real life, in real time. As we part company, I do encourage you to look out for members of your community. Your community is not just a development that you live in, it spreads far and wide. Those that you pass on the bus, the plane, the boat, the train, whether you walk, ride, or drive, these are members of your community. Do something good for one of them today, because you never know who's going to do something good for you tomorrow. My name is Kevin Stew. Just I like to do it to you, for you, and with you. Mondays, Tuesdays, Wednesdays, right here. The night shift of DJ Kevin Stew. Take care until we do it again. Good morning, good afternoon, good day to you, wherever you are in the world. From right here in South Florida, I bid you all a good night. Be good. If you can't be good at it. I'm out of here. Greetings and salutations, one and all. You're invited to tune in to the night shift with DJ Kevin Stew. It airs on Mondays with Community and Finance, Tuesdays with Healthy Love, and Wednesdays with Real Talk from 10 p.m. to midnight Eastern Time. Come spend some time interacting in the stew pot where we keep things bubbling and wind down in musical therapy. The night shift with DJ Kevin Stew is on kevinstew.com, where you're encouraged to have acceptance through enlightenment.